The Crown in Holland is a very recent case heard in the District Court of New South Wales, and it provides the first instance that I'm aware of in Australia where the defence of somnambulism, or sleepwalking, has been applied to a serious criminal offence. Holland was accused of entering the home of a woman in Coffs Harbour during the night and assaulting her. His defence was that he had a long history of truly bizarre sleepwalking behaviours and that he had conducted the assault in his sleep while dreaming that he was a character from a computer game called Skyrim. There was expert evidence before the court from a Professor Greenberg about the possibility of parasomnia, as it's called, producing complex behaviours even in someone who's still asleep. And there was evidence from the defendant's brother of previous sleepwalking events. The brother's evidence included the statement that he goes into a weird state and does crazy things and doesn't remember. Once he woke Mum up and was insisting that I was inside a sandwich bag in the wardrobe. However, there was also evidence that the defendant may have been affected by alcohol and possibly by other drugs, and that he had a history of psychological and behavioural disorders. It's a fundamental principle of our criminal law that a person can only be criminally responsible for conduct which they undertook voluntarily as a product of their own will. As a result, for instance, a person who's having an epileptic seizure and who breaks an item while in that seizure is not committing an offence by doing so. They simply had no control. The question here was whether this offence was in fact the product of the defendant's will, or whether he was genuinely sleepwalking and therefore not in any real sense responsible for his conduct. District Court Judge Marnie of Senior Counsel said, "Unless the Crown proves beyond reasonable doubt that the act of the accused was subject to the control and direction of his will, then he must be acquitted because no offence has been committed." Bear in mind, though, this doesn't provide a get-out-of-jail-free card for people to avoid criminal responsibility by claiming to have been sleepwalking. The defendant placed substantial evidence of sleepwalking before the court. Had he not done so, it would have been much easier for the prosecution to overcome any such claim.